Okay, so we're going to talk about the 14 cases that we need to know for the AP exam. You need to know the cases because they could be on both the FRQ3, right? Because you have to be able to know the case, know the facts, know the question, and know the ruling. And they can also have MCQ questions, right? You could have an MCQ question that's like, which of the following cases ruled on this issue or ruled X? Or you could have something like where they describe a scenario or something, and it's like, which of the following cases would rule this act unconstitutional or something, or uphold this practice similar to this? So you could see MCQ cases, questions that are based on the required cases. So there are 14 cases, and rather than thinking about them individually, it's more helpful to arrange them into basically 5 categories. So you have 3 cases about like the powers of the government and federalism. You have 3 cases about political participation. You have 5 cases about the First Amendment. You've got 2 cases about selective incorporation and due process, like the 14th Amendment stuff. And then you've got 1 case about equal protection clause of the 14th Amendment. You could ask why there's so many cases about the First Amendment and so few cases about other things, and why there's nothing about like privacy or nothing about administrative law or nothing about immigration law, and those would all be good questions for College Board. So I've got it. I'm going to go through like the facts, the principle, the ruling, and the impact of all the cases broken into the different categories. So if we're looking at the governmental powers cases, right, the first one we're looking at is Marbury versus Madison. Honestly, if you just know judicial review, you're fine for this one, right? You don't need to necessarily know the whole thing about like midnight judges and writs of mandamus. But the court ultimately ruled that Marbury was technically entitled to his commission, but that the Judiciary Act's provision of giving the court the power to issue a writ of mandamus is unconstitutional. And the reason we care about it is not because of Marbury's appointment as a justice of the peace, but because it basically affirmed the principle of judicial review. I have never seen an FRQ3 that's about Marbury versus Madison, but lots of MCQ questions about Marbury versus Madison. The second one is McCulloch versus Maryland. This is the national bank. Maryland wanted to tax the Bank of the United States during the Madison administration. It raised questions about like how much power does a national bank have, and the court ruled that the bank is constitutional and that Maryland cannot tax it based on the necessary and proper clause, saying that like, look, if the Constitution gives Congress the ability to print money, coin money, collect taxes, then that's necessary and proper for it to establish a bank. And the supremacy clause, that Maryland cannot tax the branch because the power to tax is the power to destroy, and that would make the states more powerful than the federal government. So it affirmed national supremacy, expanded federal power vis-a-vis the states. And the third case is U.S. versus Lopez, which is almost 200 years later, because there were no developments in federalism or constitutional law between 1819 and 1995. It's not true. There's a ton of developments in these questions. But Lopez was charged with bringing a gun to a school in violation of the National Gun-Free School Zones Act. And the question was like, can Congress outlaw handgun possession inside school zones? The government argued that it was justified under the Commerce Clause because like fear of school shootings crosses state lines and that it has a negative effect on commerce. But the court ruled that education doesn't count as commerce, that it wasn't like goods and services crossing state boundaries, and that this law exceeds the authority of the Commerce Clause. Like a state or a local government could absolutely have gun-free school zones, but that the federal government could. There could be no federal crime there. And so this limited the power of the federal government vis-a-vis the states. These ones are pretty straightforward. The trick for Lopez is just to remember that it's not a guns case, it's a federalism case. Okay. The political participation cases I think are actually the hardest ones because they're like not as flashy, I guess. So the first one is Baker versus Carr from 1961. This is Tennessee had not updated its congressional district maps to reflect demographic changes, and the question really before the court wasn't whether or not Tennessee's maps were good. It was whether or not the courts have the authority to rule over Tennessee's maps, since Article 1 of the Constitution gives state legislatures the ability to draw congressional districts. And so the question before the court was really, is this a justiciable question or is this a political question? And the courts have generally ruled that they're not supposed to make rulings on political questions, right? Like questions that should be decided by legislatures or the president. They should only be settling legal questions. And the court did rule that redistricting is a justiciable question. That means that the courts have the jurisdiction to rule on the constitutionality of maps because of the 14th Amendment's Equal Protection Clause, that if the maps are drawn unfairly, that's violating people's equal protection of the law. And this establishes the principle that like every person's vote should be more or less as equal as possible, right? Shaw versus Reno in 93 was the question of racial gerrymandering, because North Carolina had drawn a bunch of oddly shaped maps and produced only one majority-minority district, even though there's a bunch of racial and ethnic minorities in North Carolina. And so there's a lawsuit over that. And the court ruled that legislative redistricting has to be race-conscious, but cannot be only determined by race, right? So you cannot draw districts purely based on racial gerrymandering. So you can take into account race so that when you are so to avoid creating like a racially biased sample, racially biased map, but you cannot, like they ruled that the only way that you could have drawn these maps, because they didn't follow any natural boundaries or like municipal boundaries, was that you were trying to be racially discriminatory. And then Citizens United there was the corporate donations to fund a campaign video specifically about like Hillary Clinton, and the question was like, can corporate speech is this protected speech, or does this violate campaign finance laws? And the court ruled based on the First Amendment that political spending by corporations, associations, interest groups, labor unions is protected as speech, right? There are still limits on the money that they can give directly to candidates, right? But this is soft money. So this is like money given to a PAC or money given that is not to run like issue ads, right, that are not given to a specific political campaign or political party. So that type of speech is protected. And so this is like money is speech and corporations are people. And this increased the amount of like soft money or dark money into politics, right? This is money that is not given directly to a candidate or to a campaign or a political party, but is instead given to like Americans for a Better America. And then they run like ads that they do not necessarily endorse a candidate, but they're like, this person is really bad for this issue. So those are the ones. Baker and Shaw are like the most complicated ones. Like for Baker, you really just need to know that this is a question that the courts can rule on. And for Shaw, the idea that like you cannot have like racially biased political maps. Citizens United is pretty straightforward. So then there's the 5 First Amendment cases. The first one is Schenck. Schenck was arrested under the Espionage Act for distributing anti-war pamphlets, specifically encouraging people to dodge the draft. He sued, arguing this violated his free speech, and the government disagreed with Schenck and argued that the government can restrict speech that constitutes what they call a clear and present danger to the public. This is the case where the metaphor used in the opinion was that you can't yell fire in a crowded theater, but the case is not about yelling fire in a crowded theater. So like that's actually kind of confusing. The case is basically that establishes a test that like there's a compelling government interest in regulating speech that constitutes clear and present danger. So, and the key idea here is that free speech is not absolute. Then in 1962, Engel versus Vitale, this is the school prayer one. There was a New York wrote a non-denominational prayer that they started every school day with, and they invited but did not require students to like say aloud with them. They were sued about over the Establishment Clause. The Establishment Clause says basically that you can't have state-sponsored religions, and the court ruled that schools cannot sponsor prayer in schools. This was the first case to ban religious practices in public cases and like basically banning school prayer, right? You cannot have any sort of like state-sponsored school prayer. In 1969, Tinker versus Des Moines Independent Community School District. Tinker, if you just said Tinker versus Des Moines, you'd be fine. This is students were protesting the Vietnam War by wearing black armbands, and they were, I think, either suspended. I think they were suspended from school, or maybe I don't think they were expelled. They received some sort of discipline, and they argued that this violated their free speech rights. And the court held that their student protests are symbolic protected speech as long as it doesn't cause a disruption. Like if it's disruptive speech, then the school, but like simply wearing a black armband is symbolic protected speech. And the 2 key impacts of this is that like students in public schools, this doesn't cover private schools, but students in public schools retain their free speech rights within, the reasonable limits that are established in free speech law. And that like this idea of like symbolic speech is protected, right? It doesn't actually have to be like vocalizing words. So like wearing a black armband isn't saying something, but it still counts as speech. In the same way, like burning a flag, Texas versus Johnson, also is protected symbolic speech. New York Times versus U.S. was the Pentagon Papers case. The New York Times the government told the New York Times they couldn't publish the Pentagon Papers. They sued the government over this, and the court ruled that the New York Times can publish the Pentagon Papers even if they are embarrassing, even if they can deal with national security. And they established a heavy presumption against prior restraint. Prior restraint is the idea that government can tell you what you can or cannot publish in advance. It's vague on what that, there's not like a clear test. It just is basically like the burden of proof is on the government to prove why it can prevent you from publishing something. It's not simply enough that it was like deals with national security or it is embarrassing for the government. And the last one is Wisconsin versus Yoder. This is the Amish case. An Amish family pulled their kids out of mandatory public schools in Wisconsin, citing religious freedom, that part of their way of life is like remaining isolated from modern society. They argued that this compulsory attendance in public schools violated their free exercise clause rights, and the court agreed, saying that they cannot compel Amish students to attend school beyond the 8th grade. That up until the 8th grade, that there's a compelling government interest in making sure that the students are educated and cared for, but beyond that, for religious reasons, you can be exempt. And this is like kind of this is one of the earliest precedents about like religious exemptions for like other publicly applicable laws, right? That you can have a religious exemption there. Any questions for those? Okay. So selective incorporation due process cases, right? These are both about Bill of Rights questions, but also using the due process clause of the 14th Amendment to apply those Bill of Rights protections to state government. So the first one is Gideon versus Wainwright in 1963. Clarence Earl Gideon was charged with basically theft, but couldn't afford a lawyer and was convicted, and argued that the reason why he was convicted was because he couldn't adequately defend himself. He sued, saying that the state had an obligation to provide a public defender for him, arguing that this violated his Sixth Amendment right to have legal representation. Since the previous precedent by the Supreme Court had held that the state is only required to provide a public defender in capital crimes, in crimes where there is a possibility of the death penalty. And the court agreed with Gideon, saying that that the states have an obligation to provide attorney for poor and indigent defenders in all state cases. So this incorporated the Sixth Amendment's right to counsel to the states, but it didn't provide any sort of requirement of like federal funding for this. So this created a kind of like an unfunded mandate for the states. So the states had to provide these public defenders, but there was no guarantee of federal money for this, even though this was now like a federal legal requirement. The other selective incorporation case is McDonald versus Chicago. Chicago had a handgun ban, and McDonald argued that this law violated the Second Amendment's right to have to own a firearm. And this was based on a previous case that was argued 2 years before, DC versus Heller, that argued that the Second Amendment's right to bear arms meant that you could have a personal ownership of a firearm for any reason, right? You didn't have to have like a justification or a reason to own a firearm. That like as long as you were not doing crimes with that gun, right? You had a personal right to own a firearm, and so the court then applied the logic of Heller that there's an individual right to keep and bear arms for self-defense to state and local laws, so that state and locals couldn't just have like a blanket handgun ban. This incorporates the Second Amendment to the states, and this establishes what has been kind of like guiding precedent in firearm laws of the history and traditions test, that gun regulation, like it's not the Second Amendment. They agree that the Second Amendment is not an unlimited right, that like there can be no regulations or requirements on gun ownership, but that those regulations and requirements have to be consistent with the history and traditions of the country, right? So whatever that means. So those are the selective incorporate. Like for these ones, I've seen FRQ 3s where they're not really asking you what amendment is at stake, but they're asking you the legal doctrine of selective incorporation. So like that's why they're grouped together, even though like one is about like procedural due process and one is about guns. And the last one is Brown versus Board of Education. School segregation, is it constitutional? The court said no, that segregated schools are inherently unequal. It overturned Plessy and ordered, at least with regard to public schools, ordered schools to be desegregated, but this led to massive resistance in Brown versus Board 2 and a bunch of other case law about how you actually go about desegregating. This is the Equal Protection Clause is the key one here. That the segregated schools violated people's equal protection of the laws. So just some data on what cases previous exams have focused on. In 2020, this is after the 2020. So the course was redesigned in 2020 and had this like Supreme Court analysis question, which was added to the exam in 2020, starting 2020. So the first is 2021. You had cases on Citizens United and Gideon. In 2022, Citizens United again and McDonald. 2023 had Wisconsin versus Yoder and Engel Vitale, so 2 First Amendment cases. And in 2024, we had U.S. versus Lopez, so the federalism case, and Schenck versus U.S., the First Amendment case. I don't think it'll be Citizens United again, since they've already done that twice, but like they could. Like they clearly did it 2 years in a row. I always bet that it's going to be one of the redistricting cases, Baker or Shaw, and I've been wrong every year. So that's 1 year I will be right that it is Baker or Shaw. But that's just like they have kind of gone fairly broad on this. But and I've seen like sample ones that College Board has produced about McCulloch, Brown. Yeah, I think it's McCulloch and Brown, in addition, that are like official like College Board ones. So in addition to these ones, I see. So I don't know if that's helpful, but just to think about in terms of what other cases there could be.